My good wishes to the viewers. The subject of discussion in this session is sentencing theory and practice. I am Pattabhi Ramarao K, Assistant Professor, National Judicial Academy, India, situated in Bhopal. And as all of you know, sentencing is considered to be the end product of all prosecutorial and legal enforcement agencies. They want that a case is to be convicted and the wrongdoers be punished. Punishing the wrongdoers is the heart of the criminal justice system. And when we look at our penal laws, enormous discretion is given to the judges. Let us take the example of Indian Penal Code 1860, that is the chief penal code in India. It provides a lot of discretion to the judges. They can select and impose punishment according to the choice and the range. Many offences can be punished either even for a day, and it can be even punished with higher sentence, and there is no limitation except the limitation which we can find in section 354(3) and 354 of the Code of Criminal Procedure. Under section 354(3), if a judge is giving death sentence, he should record the reasons, and under section 354(4) of the CRPC, if the judge is giving sentence of less than 3 months in any case which is punishable with imprisonment for more than 1 year, he should give reasons. Except this limitation, there is no other limitation on the discretion of the judges. And what are the punishments that can be awarded? Under section 53 of the Indian Penal Code 1860, the punishments are described. Only these punishments can be awarded. They are death, imprisonment for life, imprisonment again which is of two descriptions, either rigorous or simple, forfeiture of the property, and fine. And in only serious cases, the punishment of death and imprisonment for life is prescribed, and in all other cases the judges can impose the punishment that is prescribed by the statute. Usually the punishment of forfeiture of the property is prescribed for economic offences where the wrongdoer has wrongfully gotten or acquired some property. And apart from this, competency of the court has relevance in sentencing, and section 28 to section 29 of the CRPC deals with the competence of the courts. High Court and session judges can impose any punishment that is authorized by law. Under section 28(1) of the CRPC, the High Court can pass any sentence, and under section 28(2) of CRPC, the session judge also can pass any sentence authorized by the law. However, when a session judge gives punishment of death, it should be ratified by the High Court. The session judge is required to send all the files for confirmation by the High Court. Assistant session judge can impose a sentence of imprisonment up to 10 years, and he also can impose fine, and there is no limit for the amount of fine that an assistant session judge can impose. The Chief Judicial Magistrate can award sentence up to 7 years, and Chief Judicial Magistrate can also impose unlimited fine. The Judicial Magistrate of first class can impose fine up to rupees 10,000, and he can award imprisonment up to 3 years. The Judicial Magistrate of second class can impose imprisonment up to 1 year, and he can impose fine up to rupees 5,000. There are other categories of magistrates known as Metropolitan Magistrate and Chief Metropolitan Magistrate, and they have to exercise their discretion as the Chief Judicial Magistrate and Judicial Magistrate of first class exercise. And though there are the rules and guidelines in the CRPC, the enormous discretion is causing disparity in sentencing. Writing 3 centuries ago, Hegel in Philosophy of Right said, reason cannot determine nor can concept provide any principle whose application could decide whether justice requires for an offence a corporal punishment of 40 lashes or 39, or a fine of $5 or $4.99, or imprisonment of a year or 364 days. And the disparity is there, and the disparity becomes inevitable. Yet whenever more sentence is given or more fine is imposed, injustice is done at once. And though sentencing is considered to be such an important facet of criminal justice administration, our judicial system could not develop any legal principles that can be applied in determination of appropriate sentences, nor there exists any legal framework in this regard. This resulted in colossal liberty for Indian judges, and the entire process became judge-centric. And because of this, there is huge disparity in sentencing, and because of this, there are adverse effects. Most importantly, the principle of equality is violated. Desperate sentences are considered to be violation of human rights. There are several adverse effects of sentencing disparity. The person who gets more sentence than his fellow convict who was situated in similar circumstances develops a kind of antagonism towards the society. He develops a kind of aversion to the society, and in the long run, desperate sentences cause trouble to the society, and they make the public lose confidence in the criminal justice system. Even in the year 1971, in Rameshwar Dayal versus State of UP, the Honorable Supreme Court has recognized this sentencing disparity. In this particular case, the trial court awarded sentence of 1 day, and the session judge made it as 7 years, and later the Supreme Court reduced it to 3 years. Like that, in Raju versus State of Karnataka also, such sentencing disparity was apparent. And why this is happening? This is mainly because we are not able to standardize our practices. We are not able to relate theories of punishment and the sentencing process. And because of this, we should know a little about theories of punishment when we are thinking of sentencing processes. Theories of punishment explain the purpose of punishment, and the theory says that a punishment can be justified to satisfy the feeling of vengeance in the mind of the victim on large number of people who can be collectively called as society and who share the agony of the victim. This satisfaction of vengeance of the victim and society is the foundation for the principle of retribution. And the another justification is to take away the power of offending from the offender. This is incapacitating the offender. This is called preventive theory. And the third Reformation theory advocates for removing the desire of punishments, desire of causing the offense from the mind of the wrongdoer. This is called reformation. And to make the offender afraid of consequences if the similar act is repeated, and to create fear in the minds of the persons who are disposed to commit similar offences is purpose of punishment, and this is based on the theory of deterrence. Thus, we can see that theories of punishment can be classified as retributive theory, preventive theory, reformative theory, and the theory of deterrence. And broadly, they can be classified as consequentialist theories or deontological theories. Consequentialist theories, they are concerned with the supposed effect of the punishment, whether the punishment gives any particular result, whether the punishment brings any change in the behavior of the offender, whether the punishment brings any change in the attitude of the society towards the crime. The second category is deontological, where the concern is regarding moral consideration and not the consequences of the offence, whether it is right to convict the offence, what is the justification, moral justification for sentencing the person. Andrew van Hirsch, in Proportionality in the Philosophy of Punishment, Crime and Justice, writing in the year 1992, made this broad classification.